Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Yes, it's starting to get warm and the U.S. is ready to party. From park concerts and buzzing festivals to the epic Labor Day celebrations, the season is all about music, energy, and unforgettable vibes. If you are an international entertainer dreaming of lighting up the stage here, now's your time to shine, and we at Ask the Lawyer are here to help you make it happen. Call us right now, 855-768-8845, or visit us at www.askthelawyer.us. Let's get you in front of the crowd. Listen right now.
For many artists, bands, and musicians worldwide, performing in the United States represents a significant opportunity to expand their careers and connect with a global audience. The U.S. entertainment industry is one of the most vibrant and diverse markets, offering international performers the chance to reach new fans, collaborate with American talent, and experience the rich cultural landscape of the country. However, to legally perform in the U.S., artists, musicians, and entertainers must obtain the proper visa, usually under the P visa category. In this comprehensive guide, we will analyze the process for an artist, band, or musician living overseas to successfully apply for an entertainer visa, specifically the P1, P2, and P3 visas. We'll cover the eligibility requirements, application procedures, the role of the U.S. consulate in the process, and practical advice for navigating the complexities of U.S. immigration law for performers. Understanding U.S. entertainment visas, P1, P2, and P3. The P visa category is designated for internationally recognized performers, artists, and entertainers who want to come to the U.S. to participate in a specific event, tour, or performance. Unlike the O1 visa, which is for individuals with extraordinary abilities, the P visas are tailored for those who are part of a group or collaborative effort and may not necessarily need to meet the same stringent requirements. Here's a breakdown of the three main types of P visas. P1 visa, internationally recognized performers. The P1 visa is for artists, bands, and entertainers who are part of a group that is internationally recognized. It allows foreign nationals to come to the U.S. to perform in an internationally recognized entertainment group, participate in an event, or compete in a cultural or sporting event. Eligibility. To qualify for a P1 visa, the group or individual must have an internationally recognized reputation in their field. This means that the group or act should have achieved recognition beyond their home country and be well known in multiple countries. Duration. The P1 visa is granted for the duration of the performance or event, typically not exceeding 1 year. Extensions are available in 1-year increments as long as the performer remains engaged in the same event or tour. P2 visa, reciprocal exchange program. The P2 visa is for artists or entertainers who are participating in a reciprocal exchange program between an organization in the U.S. and one in another country. This visa is designed to facilitate cultural exchange through performances, workshops, or collaborative artistic endeavors. Eligibility. Applicants must be part of a reciprocal exchange program recognized by the U.S. government. The exchange program must involve artists of similar talent and background in both countries, ensuring equal opportunities for both American and foreign participants. Duration. The visa is granted for the length of the exchange program or event, not exceeding 1 year, but extensions are possible under certain conditions. P3 visa, culturally unique artists. The P3 visa is for performers or entertainers who are coming to the U.S. to participate in a culturally unique program. This visa allows artists to present, teach, or coach performances that highlight cultural traditions, ethnic expressions, or folklore unique to their home country. Eligibility. The applicant must prove that their performance is culturally unique and that they will participate in an event, program, or workshop that highlights or promotes their cultural heritage. Duration. The P3 visa is granted for up to 1 year, with the option to apply for extensions. Each of these visa categories has specific requirements and procedures, but they all share the common goal of allowing foreign artists, entertainers, and performers to legally work and perform in the U.S. Step-by-step process for applying for an entertainer visa. Step 1. Secure a U.S.-based sponsor or employer. The first step in obtaining a P visa is securing a U.S.-based sponsor or employer. Unlike tourist visas, which are self-petitioned, a P visa requires a petition from a U.S. organization, agent, or employer. This could be a concert promoter, music festival organizer, cultural institution, or a venue hosting the performance. Who can be a sponsor? The sponsor must be a U.S. entity or individual who has the authority to petition on behalf of the artist or group. The sponsor is responsible for submitting the visa petition and must show evidence that they are hiring the foreign performer for a legitimate event, tour, or project in the U.S. Step 2. File Form I-129, Petition for an Immigrant Worker. Once a sponsor or employer is identified, they must file Form I-129, Petition for an Immigrant Worker with the U.S. Citizenship and Immigration Services, USCIS. The I-129 form is the primary application that sets the process in motion and must be completed by the U.S. petitioner. Supporting documents. Along with Form I-129, the petitioner must submit supporting documentation that includes a detailed explanation of the event or performance schedule, contracts or letters of intent outlining the terms of the engagement, proof of the artist's or group's eligibility, e.g. international recognition for P1, evidence of a reciprocal exchange for P2, or proof of cultural uniqueness for P3, documentation of previous international performances or tours for P1. Filing fee. As of 2024, the filing fee for Form I-129 is $460, though it's essential to check the latest USCIS fees. Step 3. Wait for USCIS approval. Once Form I-129 is submitted, USCIS will review the petition to ensure it meets all the requirements for the specific P visa category. Processing times for USCIS can range from several weeks to several months. However, for those needing faster processing, premium processing is available for an additional fee, which expedites the decision within 15 calendar days. Approval notice. If USCIS approves the petition, they will issue a notice of approval, Form I-797, which is necessary for the next step, applying for a visa at a U.S. consulate. Step 4. Apply for a visa at the U.S. consulate. Consular processing. Once USCIS approves the petition, the artist, band, or musician must apply for their visa at the U.S. consulate in their home country. This step involves several important tasks. Complete Form DS-160. All visa applicants must fill out Form DS-160, the online non-immigrant visa application. This form collects personal and background information about the applicant, including details about previous travel, employment history, and intended activities in the U.S. Schedule a visa interview. The applicant must schedule an interview at the U.S. consulate or embassy in their home country. The wait time for interview appointments varies depending on the location, so it's important to book the appointment as early as possible. Documents to bring to the interview. Passport, valid for at least 6 months beyond the intended stay in the U.S. Visa application fee payment receipt. As of 2024, the fee is $190 for P-Visas. Form I-797, Notice of Approval, from USCIS. Confirmation page of Form DS-160. A passport-sized photo that meets U.S. visa requirements. Any additional documentation that supports the purpose of the trip, aid contracts, event details, or a letter from the sponsor. Visa interview. During the visa interview, a consular officer will ask questions to determine the purpose of the visit, the duration of the stay, and the artist's ties to their home country. The officer will also verify the details provided in the visa application and the I-129 petition. If the interview is successful, the visa will be approved. Step 5. Enter the U.S. and begin performing. Once the visa is approved, the applicant will receive their visa stamp in their passport. The visa allows them to enter the U.S. for the specified duration of their performance, tour, or event. Upon arriving at a U.S. port of entry, they will be inspected by a Customs and Border Protection (CBP) officer who will issue an I-94 arrival departure record that specifies how long the artist can remain in the U.S. Special considerations for artists, bands, and musicians. Multiple members of a group. For bands and performing groups, the P-1 visa can cover all members of the group if they meet the criteria for international recognition. However, each member must be part of the group for at least 1 year before the application, except in cases of illness or other emergencies that necessitate temporary replacements. Essential support personnel. In addition to the main performers, essential support personnel, such as sound engineers, makeup artists, or production crew, can also apply for P-visas under the P-1S, P-2S, or P-3S categories. These visas are for individuals who are integral to the success of the performance and who have critical skills that cannot be easily replaced by a U.S. worker. Traveling on multiple performances or tours. Artists, musicians, or bands playing multiple performances or tours in the U.S. can apply for P-visas that cover the entire duration of their tour schedule. If the performance schedule changes, the sponsor or agent must notify USCIS and, if necessary, file an amendment to the original I-129 petition. Dual intent and future immigration options. While the P-visa is an immigrant visa, it allows for dual intent, meaning the artist can apply for permanent residency, green card, later if they meet eligibility requirements. This is particularly important for artists who may wish to pursue a more permanent career in the U.S. The U.S. offers a vibrant and diverse landscape for artists, bands, and musicians from all over the world to showcase their talents and contribute to the cultural richness of the country. However, to legally perform in the U.S., foreign artists must navigate the complexities of U.S. immigration law, specifically by applying for the appropriate P-visa category. The process of applying for a P-visa involves securing a U.S.-based sponsor, filing Form I-129 with USCIS, and attending an interview at the U.S. consulate in the applicant's home country. While the process can be complex, careful preparation and attention to the specific requirements of each visa category can help ensure a successful application. For artists looking to pursue multiple performances, tours, or cultural exchanges, the P-visa offers a flexible and reliable pathway to performing in the U.S. The law firm of Figueroa & Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hire does make a difference.
Got legal questions? Tune in to Ask the Lawyer on Inception FM, where attorney Brian Figueroa of Figueroa & Associates delivers real solutions to your legal challenges. From immigration and family law to civil rights and business matters, we've got you covered. Join us every Saturday at 8 a.m. and Thursdays at 6 p.m. for expert insights and empowering discussions. Don't miss out. Visit InceptionFMradio.com to learn more.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay. But the law firm of Figueroa and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845. Get the right legal help when it matters most.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Derivative U.S. citizenship. Before and after the Child Citizenship Act of 2000, derivative citizenship refers to the automatic acquisition of U.S. citizenship by a child through the naturalization of their parents, without the need for the child to undergo the naturalization process themselves. The legal framework governing derivative citizenship has evolved over time, with significant changes introduced by the Child Citizenship Act of 2000 (CCA), which became effective on February 27, 2001. This analysis explores the criteria for derivative citizenship before and after the CCA and outlines the documentation required to establish such status. Derivative citizenship before the Child Citizenship Act of 2000, legal framework, former INA 321. Prior to the CTA, the Immigration and Nationality Act, INA, provided for derivative citizenship primarily under Sections 320 and 321. Former INA 321 was the principal statute governing the automatic acquisition of citizenship by children born outside the United States to alien parents. Under INA 321, a child born outside the U.S. could derive citizenship through the naturalization of their parents, if specific conditions were met. Eligibility criteria under former INA 321. To qualify for derivative citizenship under former INA 321, the following conditions had to be satisfied before the child reached 18 years of age. 1. Parental naturalization. Both parents had to naturalize as U.S. citizens. However, exceptions existed. If one parent was deceased, the surviving parent's naturalization sufficed. If the parents were legally separated or divorced, the naturalizing parent had to have legal custody of the child. If the child was born out of wedlock and paternity was not established, the mother's naturalization was sufficient. 2. Child's age. The child had to be under 18 years of age at the time the parents naturalized. 3. Residency. The child had to reside in the United States as a lawful permanent resident, LPR. At the time of the parents' naturalization or thereafter begin to reside permanently in the U.S. while under the age of 18. It's important to note that under former INA 321, the requirement for both parents to naturalize was strict, with limited exceptions. This often posed challenges for children in single-parent households or where one parent was unwilling or unable to naturalize. Documentation required under former INA 321. Establishing derivative citizenship under former INA 321 required comprehensive documentation to prove eligibility. Proof of parents, naturalization certificates or U.S. passports of the parents. Child's birth certificate to establish the parent-child relationship. Legal custody documentation. Court orders or legal documents demonstrating that the naturalizing parent had legal custody of the child in cases of divorce or legal separation. Proof of lawful permanent residency. The child's permanent resident card, green card, or other evidence of LPR status. Evidence of residence in the U.S. Documents showing the child's physical presence and residence in the United States during the relevant period. Additional documents. In cases involving children born out of wedlock, evidence that paternity was not established by legitimation, such as affidavits or lack of paternity acknowledgement.
Applicants seeking recognition of derivative citizenship under former INA 321 typically file Form N-600, Application for Certificate of Citizenship, with the U.S. Citizenship and Immigration Services, USCIS, providing the necessary supporting documents. Derivative citizenship after the Child Citizenship Act of 2000. Legal framework. Amended INA 320. The Child Citizenship Act of 2000 significantly simplified the process for children to acquire U.S. citizenship through their parents. The CCA amended INA 320, making it the sole provision for automatic acquisition of citizenship for children residing in the United States. The Act also repealed INA 321, thereby removing the previous requirement for both parents to naturalize. Eligibility criteria under amended INA 320. Under the amended INA 320, a child born outside the United States automatically acquires U.S. citizenship when all the following conditions are met on or after February 27, 2001. 1. Parents' citizenship. At least one parent is a U.S. citizen, either by birth or naturalization. 2. Child's age. The child is under 18 years of age. 3. Lawful permanent residency. The child is residing in the United States as a lawful permanent resident. 4. Legal and physical custody. The child is residing in the legal and physical custody of the U.S. citizen parent. Unlike the previous law, the amended INA 320 does not require both parents to be U.S. citizens or to have naturalized. This change has made it significantly easier for children in single-parent households or with one non-citizen parent to acquire U.S. citizenship. Documentation required under amended INA 320 to establish derivative citizenship. Under the amended INA 320, the following documentation is typically required: proof of parents' U.S. citizenship, U.S. passport, birth certificate, or naturalization certificate of the parent. Child's birth certificate, to confirm the parent-child relationship. Proof of lawful permanent residency, the child's permanent resident card, green card. Evidence of legal and physical custody, documents such as court orders, school records, or tax returns demonstrating that the child resides with the U.S. citizen parent. Proof of residence in the U.S., evidence showing the child's physical presence and residence in the United States. Applicants can file Form N-600, Application for Certificate of Citizenship, with USCIS to obtain official recognition of their derivative citizenship status. The form requires submission of the aforementioned documents to substantiate the claim. Comparative analysis. Before and after the CCA, the enactment of the Child Citizenship Act of 2000 marked a significant shift in the landscape of derivative citizenship. Key differences between the pre- and post-CCA frameworks include parental naturalization requirements. Former INA 321 required both parents to naturalize, with limited exceptions, whereas amended INA 320 requires only one parent to be a U.S. citizen. Custody considerations. The pre-CCA law necessitated legal custody in cases of divorce or separation, often complicating eligibility. Post-CCA, the focus is on the child residing in the legal and physical custody of the U.S. citizen parent, simplifying the process. Residency requirements. Both frameworks require the child to be a lawful permanent resident residing in the U.S., but the CTA provides clearer guidelines and broader applicability. Application process. While both require filing Form N-600 for official recognition, the documentation and eligibility criteria under the CCA are more straightforward, reducing the burden on applicants. Overall, the CCA has streamlined the process for children to acquire U.S. citizenship through their parents, reflecting a more inclusive and accessible approach. Conclusion. Understanding the evolution of derivative citizenship laws is crucial for individuals seeking to establish their U.S. citizenship status through parental naturalization. The Child Citizenship Act of 2000 has significantly simplified the criteria and process, making it more accessible for eligible children. Proper documentation remains essential in substantiating claims of derivative citizenship, and applicants are encouraged to consult with immigration professionals or USCIS resources to navigate the application process effectively.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
I have been deported. Can I return to the United States? Returning to the U.S. after deportation is a challenging process, but is not impossible. Here are some key points. A. Deportation grounds. People are deported for various reasons, including entering the United States without permission, B. Violating immigration status terms, C. Criminal offenses leading to deportability, and D. Security-related concerns. Things to consider are A. The inadmissibility period. After deportation, individuals are inadmissible for a specified period. The length of inadmissibility depends on the reasons for removal, the number of removals, and whether they left voluntarily or after removal hearings. Some grounds of removal allow for waivers, except security-related grounds. Waivers may reduce the waiting period for re-entry, and severity of removal grounds affect waiver approval likelihood. How to get back. Form I-212 application. Individuals seeking re-entry file Form I-212 to request permission. USCIS then reviews the application and grants permission if eligible. Please note that U.S. citizens cannot be legally deported. They can return to the U.S. at any time. How to prove that you're a U.S. citizen? Determining your U.S. citizenship depends on various factors. Here are some scenarios to consider. Were you born in the U.S.? If you were born in the U.S., your birth certificate issued in the United States is proof of your citizenship. Do you have grandparents or parents born in the United States? You may be a U.S. citizen if one of your parents or grandparents was born in the United States or its territories. Additionally, if one or both of your parents became a naturalized U.S. citizen before your 18th birthday, you may also be a U.S. citizen. Naturalization. If you're a lawful permanent resident, a green card holder, you can apply for naturalization after meeting specific requirements established by Congress in the Immigration and Nationality Act. Always remember to consult a legal professional. For personalized guidance, consult with the immigration attorney or visit the U.S. Citizenship and Immigration Services website for detailed information.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa & Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.